So good afternoon and welcome to the Health and Government Operations Committee. It is Friday, actually 1:08 in the afternoon, and we are voting on list number 4. And I thank all the members for coming. I know it's been a long week. Thank you for your hard work in subcommittee and staff, council, everyone for keeping us on track. We really appreciate it. We have on the list 2 withdrawals. Is there a motion? 3. Is there a motion? Second? Wonderful. Is there any concerns regarding those bills being withdrawn? All those in favor say aye. Aye. Any opposed? Wonderful. The first bill that we're going to do is House Bill 53, Human Services, Maryland Statewide Independent Living Council, and that is Aaron.
This bill codifies the Maryland Statewide Independent Living Council as an instrumentality of the state. There's a reprint of the bill on pages 1 through 5 of your packet that reflects amendments adopted in the Public Health and Minority Health Disparities Subcommittee. The amendments clarify that the designated state entity has the responsibility for providing administrative support and disbursement of funds to the council, provides that the council must work in conjunction with the Centers for Independent Living, and strikes references to a board of directors.
Okay, and that was Delegate Bagnall.
The amendments were offered by the sponsor. There was no opposition, and the bill, as amended, passed unanimously.
It's been moved and second. Any discussion on the amendments? On the bill as amended, is there a second? All right. Any discussion on the bill as amended? All those in favor say aye. Aye. Any opposition? Does anyone not want to be a co-sponsor of this bill? Please raise your hand. All right, everyone wants to be on it. Thank you very much for the hard work. Next, we have House Bill 58, Open Meetings Act, State Ethics Commission, Maryland State Agency Transparency Act of 2023, and that is Lindsay.
This bill makes the State Ethics Commission subject to enhanced requirements under the Open Meetings Act. There are amendments on page 6 in your packet that require the Department of Information Technology to provide the technical staff support and equipment necessary to live stream the open meetings of the Commission and change the effective date of the bill. These amendments are the same as were adopted on the Senate cross-file. It was considered in Government Operations Subcommittee.
Thank you, Lindsay, for your work. Delegate Kerr.
Chair, there was no problem in subcommittee. We adopted the amendment and then voted the amended bill unanimously.
Is there a motion on the amendments? Second. It's been moved and second. Any discussion? Okay, on the amendments, all those in favor say aye. Aye. Any opposition? On the bill as amended? Is there a second? It's been moved and second. Any discussion? Seeing none, all those in favor say aye. Aye. Any opposition? Is there someone that does not want to be on this bill? All right. We're going to hold 111 until the end. House Bill 241, State Board of Physicians dispensing permits. Lindsay.
This bill transfers oversight of the inspection of the offices of physicians who prepare and dispense a prescription drug or device from the Office of Controlled Substances Administration, also known as OCSA, to the State Board of Physicians. The bill also moves related provisions from the Maryland Pharmacy Act to the Maryland Medical Practice Act. The board must enter and inspect a physician's office within 6 months after issuing an initial dispensing permit and at least once during the duration of a renewed permit. The board must report any violation related to controlled dangerous substances found during the required inspections to OCSA. And uncodified language transfers from OCSA to the board all appropriations, books, and records, and employees and positions assigned more than 50% of the time to a function relating to conducting the inspections. There are amendments that appear on page 12 in your packet that require the board to report violations relating to controlled dangerous substances found in the course of an inspection to the Office of the Attorney General in addition to OCSA, and authorizes OCSA to provide copies of a record rather than an original record to the board when transferring materials related to physician dispensing permit inspections.
Delegate Rosenberg. Oh, he's not here. Okay. So what was the vote in committee?
The subcommittee vote was unanimous, and this bill also was introduced in 2022 and passed the House unanimously.
Move the amendment.
All right, been moved and second. Any discussion on the amendments? All those in favor say aye. Any opposition on the bill as amended? It's been second. Is there a second? Moved and second. Any discussion on the bill as amended? Seeing none, all those in favor say aye. Any opposition? Does someone not want to be on this bill? Thank you. So next we have House Bill 242, massage therapy definition and reimbursement. Lindsay.
There's the definition, excuse me, of massage therapy to include the treatment of illness, disease, or injury. The bill also repeals language specifying that a nonprofit health service plan, insurer, health maintenance organization, or person acting as a third-party administrator is not required to reimburse a licensed massage therapist or registered massage practitioner for any services rendered. This was considered in Health Occupation Subcommittee. There are no amendments, and the vote in subcommittee was unanimous.
Thank you so much. No amendments, so on the bill as amended? Is there a second? Moved and second. Any discussion on the bill as amended? Seeing none, all those in favor say aye. Any opposition? And we cannot add co-sponsors because there are no amendments. Just to refresh for our new member, when there are no amendments, we cannot add anyone. Thank you. It just makes it hard for staff. The next bill we have is the House Bill 273, Health Occupations, Environmental Health Specialists, and Revisions. And we don't want to add work to you guys. You guys are already working like for 10 people. Go ahead, Lindsay.
As introduced, this bill expanded the definition of practice as an environmental health specialist, altered educational and experience requirements for applicants seeking licensure as an environmental health specialist, and altered grounds for which the State Board of Environmental Health Specialists may take disciplinary action. The bill also authorized the board to approve an examination provider to administer the licensing examination in lieu of administering the exam itself, and altered procedures with regard to final decisions or orders of the board. There is a reprint of the bill starting on page 13 in your packet that removes from the bill proposed new language relating to emergency preparedness from the definition of practice as an environmental health specialist, removes from the bill proposed new language that would have authorized the board to approve an examination provider to administer the examination, and removes from the bill proposed new language relating to final decisions and orders of the board, and changes the effective date of the bill. So with all those removals, what's left in the bill is changes to the educational and experience requirements for applicants and the ability of the board to take action for misfeasance or malfeasance while performing duties of an environmental health specialist. These amendments were considered in the Health Occupation Subcommittee, and the vote was unanimous.
Move the amendment.
Is there a second? Moved and second. Discussion on the amendments? Okay, yes.
These things were removed because the department and the environmentalists, the people who are the specialties said it was redundant and unnecessary. Is that right? Why was this taken out?
Go ahead.
Madam
The
Chair.
sponsor?
Yes. They were taken out for a couple of different reasons. The definition for emergency preparedness was not clear. The Senate had a lot of questions, and the Senate was not going to approve it. So in order to conform to the Senate, we wanted to make sure the bill would pass. We're going to work with them in the interim to get a better definition for what emergency preparedness means so that they can actually comply with what they're trying to do. So that was on the definition section. What was your other question?
So, and there was another section that was taken out.
The other section that was taken out just leaves current law in place. That was the section on judicial appeals. Currently, it was to allow people to do judicial appeals, but the judiciary wouldn't have the opportunity to issue a stay in those cases. Under current law, appeals go through the board and the secretary, and they can issue a stay under the Administrative Proceeding Act. So we're keeping current law.
Okay, and on the emergency preparedness, in this gap between, well, it stays the way it is now, right?
Correct.
So we don't change it, so there's no lag. It's just that the feeling of you and the Senate sponsor is that we can still come back and do a better job of it, but we're not without some definition.
Correct. Current law is still in place. They need to work with the people that were opposed to come up with a better definition of what emergency preparedness means in the context of environmental health specialists.
Thank you. Thank you, Madam Chair.
Do you think she's ready for the floor? Okay, wonderful. Any other discussion? No, this is the place for the question, and I welcome it, okay? I really do. Are there any other concerns with the bill? Wonderful. Oh, actually, the amendments. All those in favor of the amendment, say aye. Any opposition? On the bill, it's been moved. Is there a second? Any discussion? Seeing none, all those in favor say aye. Any opposition? Does anyone not want to be on the bill? Delegate Riley? Delegate Shalega? All right. Thank you. So next we have House Bill 278, Delegate, actually, Health Occupations Clinical Nurse Specialist Prescribing. Lindsay?
This bill authorizes a clinical nurse specialist to practice as a clinical nurse specialist for the purpose of prescribing drugs and durable medical equipment. The bill designates a CNS as an authorized prescriber under the Maryland Pharmacy Act and specifies that practice as a CNS is governed by rules and regulations adopted by the Maryland Board of Nursing and concern additional acts in the practice of registered nursing. There are amendments in a reprint that begin on page 21 of your packet that includes individuals who hold a multi-state license under the Nurse Licensure Compact under the definition of clinical nurse specialist and make technical changes to the cross-references under the Maryland Pharmacy Act. These amendments were considered in the Health Occupations Subcommittee. The vote was unanimous, and the origin for those amendments was the Board of Nursing.
Wonderful. So who is the Delegate Collison is not here. On House Bill 278, is there any, may I have the amendments moved? Someone move the amendments? Oh, he's getting settled. Move the amendments. It's been second. Any discussion on the amendments? Yes. Delegate Rosenberg, we are on House Bill 278, the Health Occupations Clinical Nurse Specialist Prescribing. And there's a question from Delegate Hill.
So I have a note here that when we did the CNA's prescribing authority, we did a limitation on the number of days after surgery. And the question was because this particular group, the clinical nurse specialist, has a different purview, that's not the right word, than the LPNs and nurse midwives. Was there any discussion about limiting their prescribing authority to non-CDSs, or was there any discussion about whether they need to have CDS prescribing authority?
It did not come up.
So I guess, Lindsay have any thoughts about why that would or would not be, why this is not a problem? They were described as having primary responsibility for coordinating discharges and some other kind of stuff, not full primary care stuff, and I'm just not clear on why.
You want to hold the bill, Delegate?
Not if I, no, F it. Let them do whatever they want to do. It's fine. I just was raising it.
We can hold it.
All right, then hold it. I mean, I'm
Why
not sure-
don't you hold it and work with Lindsay and ask, and the primary sponsor, Delegate Collison, and then we can put it on the next voting, okay? We don't pass bills just to do what we want to do. We are thorough here, so let's give you the time to look into it, okay?
All right, well,
Let's hold it. Next, House
sure
Bill
that's how it
321, Cigarette Restitution Fund, Payments for Sale and Marketing of Electronic Smoking Devices. Aaron?
This bill requires the Cigarette Restitution Fund to include a separate account consisting of payments received by the state as a result of litigation related to the sale and marketing of electronic smoking devices. Distributions from the separate account may be used to supplement general fund appropriations for specified programs that aim to reduce the use of tobacco products by individuals younger than age 21. There is an amendment on page 25 that was adopted in the Public Health and Minority Health Disparities Subcommittee that broadens the enforcement actions from which payments can be received and clarifies that distributions must be consistent with other provisions of state law related to the Cigarette Restitution Fund.
Delegate Bagno?
Thank you, Madam Chair. This bill does not have a cross-file. There was no opposition, and the vote was unanimous in subcommittee.
All right, is there a motion on the amendments? Move the amendment. Second? Any discussion? Yes, Delegate Riley.
Thank you, Madam Chair. Sorry, I did want to be at the subcommittee, but I was not there for reasons.
It's okay.
So anyway, I had a question. So is this time to take a question? Yes?
Absolutely, and
Okay,
it's
before we go
encouraged.
forward. All right. So I noticed in the bill, so of course, the cigarette restitution fund encompasses the monies where our Boost program comes out of currently. Isn't that true? Yes? Okay, all right, thanks. So I'm not sure, why we have to have another special fund or special, allocation in a fund that's already set up to be special, and we've already made, decisions to have the Boost funds to come out of this fund. So is that going to jeopardize that? Because then those payments obviously won't be able to go to Boost.
Let me ask the sponsor, Delegate Rosenberg, to address your question.
Okay, thank you.
My
Thank you.
pleasure.
This is an additional source of money. The basics, or the original and principal source of money for this fund is the settlement with the tobacco industry, reached more than a decade ago. And the money for Boost is taken from this fund. But because the fund allowed money to go to Medicaid to a great degree and not to specific instances more directly related to cigarettes, what we've done is, in this bill, is say that any money from a settlement with a manufacturer or distributor of electronic cigarettes, which are marketed to people 21 and younger, that money is to go for one of the already specified uses of the fund, discretionary, but in this instance, it would be solely for educational purposes with minors 21 and younger. So consistent, to make sure it's used consistent with this new money is used consistent with the purposes of the fund, and it is not at the expense of the Boost program.
Okay, thank you very much.
Any other questions? Delegate Chisholm?
Thank you, Madam Chair.
My pleasure.
I was reading the bill too, and I just wanted to make sure I understand. I think I got it. But, so the money comes into this fund that we're going to set up separately, then it goes to the general fund, and it must be dispensed in the way that it's described in the bill. I guess my question is, are we doing that because the funds were misappropriated before, or we just want a proper accounting?
It's to require, there have been no problems with the expenditure of money in this fund. The money does not go to the general fund. It goes to this separate fund. And this is just to emphasize, prioritize within the fund how the money is to be used. And actually, it mandates that it be used for this specific purposes. There have been no, that I am aware of, and I assume I would have heard about them, no problems raised with regard to the expenditure of funds from the cigarette restitution fund.
As it says in the bill, may be used only to supplement the general fund appropriation. So I took that to mean that this money goes from this account into the general fund, to supplement the general fund and then paid out.
I believe the purpose of that is so that the money is spent, so that you're not reducing what's already spent for this purpose from the general fund, so that we're adding on to what's spent under the general fund with this appropriation. Sure.
And Aaron is confirming that.
In the cigarette restitution, cigarette lawsuit from 1999, I believe. So it's a lot of money. That's why I just wanted to make sure.
No, this is the place to ask the question. Please, I encourage it, okay?
Thank you.
100%. Delegate Shalega.
Thanks, Madam Chair. How much money are we talking about?
I believe in the current fiscal year it would be 13 million.
13 million will go towards efforts to stop people under 21 from using e-cigarettes.
Cigarettes, tobacco products in general,
All tobacco, including E.
yes.
Okay. And do you anticipate this fund will grow? Or is this a one-time settlement? I mean, the cigarette restitution lawsuit was very publicized. What's the background on this? Is it going to grow to 50 million and then we're spending 50 million on that, or?
Well, it is expected that, it's certainly likely that there will be other settlements with e-cigarette manufacturers. So it certainly is within the purview of the committee now or later to, when there is a subsequent settlement that would provide more money under this bill if it becomes law, to review how the money's being spent and are there other I would hope, other cigarette-related uses to which the money could be put in addition to those under the age of 21.
All right, so this is just an initial amount of money coming in and an initial purpose for it.
Right, but if there were to be another settlement, the money would be used for, if this bill passes, the money would be used strictly for educating people under the age of 21. We would have to take subsequent action legislatively for money to be used for other purposes.
Thank you.
Thank you for the questions. Delegate Riley.
Sorry.
okay.
Yes, I just had another question. So once these funds go into this special account, what remaining stays into the current fund that we could use for other sources like Boost? Will there still be enough funding in there to support other plans or the other programs that are within this fund? And do you know what types of things are going into the fund to make sure, or what's left in the balance? If all of this money is going into a special fund, what's left that we can work with?
Well, this bill doesn't touch the other money. It has no effect on the other money.
Right, but do you have an
to answer your
idea
question,
how much money's in that currently?
I don't know what the annual
Okay.
amount is, but there are specified uses, including those related to the problems caused by cigarettes, treatment of the diseases caused by cigarettes, trying to find a cure for those diseases. But then there's also the discretionary part, which is how Boost is funded.
And then just to follow up, so I think, how back in, I think it was 2017, how we actually allowed for the Boost program to be paid out of this fund was because a lot of these kids that are in the Boost program going to these specialty schools, they felt that that was a group of people that is definitely affected by tobacco and cigarette smoke and such. So I think that's, why the legislature at the time felt that that was a good plan to do, and I just don't want that, to go away. So I was just wondering how much money still stays in the pot that we can still work in reference to that Boost program.
This bill in no way, shape, or form would affect the money now going into the fund from the settlement with the tobacco companies, which is the principal, if not the only source of funding for the fund as a whole.
Thank you for your questions. Delegate Bandari.
For point of clarification, the total, the amount for the settlement was 434.5 million. The settlement amount for Maryland is currently unknown, so that's on the MDH letter, just point of clarification.
Any other questions? These are great questions. Any other questions? Wonderful. I love the discussion and encourage it. On the amendments, since there are no other further discussions or concerns, all those in favor, they've been moved. Second? All right. All those in favor say aye. Any opposition? On the bill as amended? It's been moved and second. Any discussion on the bill as amended? Seeing none, all those in favor say aye. Any opposition? All right. Does anyone now want to be on the bill? Raise your hand. Delegate Shalega, Delegate Riley. Okay. Oh, Delegate Shalega, Delegate Chisholm, Delegate Morgan, and Delegate Hutchinson, and Delegate Riley. Okay? Okay. All right. Thank you for the discussion. That is what I like to see, okay? This is the place to do it. Next, we have House Bill 328, which is actually State Finance and Procurement Grant Prompt Payment Requirement. This is Lindsay.
This bill establishes the policy of the state to make payments under specified grant agreements and also establishes when interest accrues on amounts that are due and payable but remain unpaid on those agreements. There are amendments that appear on page 26 in your packet that clarify that the definition of a grant applies only to financial assistance made to a nonprofit organization exempt from taxation under 501C of the Internal Revenue Code, and that is to be used to provide for incremental payments, repeals the definition of late payment from the bill, alters the time period within which it is the policy of the state to make payments under a grant agreement from 30 days to 37 days, makes a grant-making entity liable for interest on an amount for which the grant-making entity has received and failed to submit an invoice to the comptroller within 30 days of receipt, alters the time period within which interest begins to accrue from the 31st day to the 38th day after the day on which the grant-making entity receives a proper invoice, and repeals language authorizing interest to accrue a certain period of time after the day on which payment becomes due under the grant agreement, repeals language specifying that a grant-making entity review an invoice not later than 5 business days after receipt, requires the comptroller to make payment on a proper invoice within 5 business days rather than 1 business day, and specifies that the requirements of the bill do not create liability on the comptroller for interest accrued on a late payment. And these amendments were considered in the Government Operations Subcommittee.
Delegate Kerr.
Thank you, Madam Chair. The committee adopted the amendments and was a unanimous vote on the bill as amended. I move the amendments.
Any discussion on the amendments? All those in favor say aye. Any opposition? On the bill as it's been moved. Is there a second? Wonderful. Any discussion? All those in favor say aye. Any opposition? And this has amendment. Who does not want to be on the bill? Thank you very much, Lindsay and Delegate Kerr. Next, we have the Maryland Lynching Truth and Reconciliation Commission reporting and sunset extension, House Bill 339, and that is Lindsay.
This bill extends the termination date for the Maryland Lynching Truth and Reconciliation Commission and also the deadline by which the commission must submit a final report of its findings and recommendations to the Governor and General Assembly. There's an amendment on page 28 of your packet that extends the final reporting date and termination date of the commission by 2 years instead of 1 year. And these were considered in Government Operations Subcommittee.
Delegate Kerr.
Thank you, Madam Chair. The committee adopted the amendments, and Lindsay, do you remember what the vote was? Unanimous vote in committee. I move the amendment.
It's been moved and second. Any discussion? All those in favor say aye. Aye. Any opposition? On the bill as amended. It's been moved and second. Any discussion? All those in favor say aye. Aye. Any opposition? Who does not want to be on the bill? Delegate Shalega. Okay. Next, we have House Bill 377, Montgomery County Village of Friendship Heights Special Taxing District Procurement. And that is Lindsay.
This bill raises the contract value threshold from $5,000 to $20,000, above which the Friendship Heights Village Council must solicit competitive bids for a contract, and also authorizes the council by majority vote to enter into an emergency contract that exceeds $20,000 in value without seeking competitive bids. The bill also defines an emergency, and there are no amendments on this bill. It was considered in Government Operations Subcommittee.
Delegate Kerr.
Thank you, Madam Chair. Local bill, no controversy. It passed the subcommittee unanimously.
Rondo, any discussion? All those in favor say aye. Aye. Any opposition? Next, we have House Bill 395, State Government State Facility Changes and Closures Procedures. Lindsay.
This bill establishes specified notice, public hearing, and reporting requirements when a principal department of the executive branch of state government seeks to close a state facility. The bill also modifies existing notice and public hearing requirements that must be followed when a principal department seeks to change the use, purpose, or function of a state facility, lease or purchase property for the purpose of providing health, juvenile, or correctional services to clients or inmates, or recommence operations of a state facility. The bill expands the notice and hearing requirements in each of these circumstances to apply for a facility to which 25 or more state employees are regularly assigned, and the bill also specifies that it may not be construed or altered to diminish an exclusive representative's right to bargain. There are amendments in a reprint that appear on page 29 of your packet that authorize a principal department to modify the timelines required under the bill if a government agency or judicial body determines that an emergency situation poses a risk to the health or safety of patients, inmates, residents, or employees of a state facility, requires the report submitted on the closure of the facility to explain the closure rather than justify it, and requires the report to adjust plans for assisting the patients, inmates, or residents affected by the closure. These were considered in Government Operations Subcommittee.
Delegate Kerr.
Thank you, Madam Chair. The committee adopted the amendments and passed the bill out of committee unanimously. I move the amendments.
It's been moved in second. Any discussion on the bill? I'm sorry, on the amendments? Seeing none, all those in favor say aye. All right, any opposition on the bill as amended? It's been moved in second. Any discussion? Seeing none, all those in favor say aye. Any opposition? All right, who wants to be on the bill? Who does not want to be on the bill? Much easier to ask that question. Shalega? Okay, Shalega and Riley. Okay. Next, we have House Bill 401, Health Occupations Practice Audiology Definition. Lisa.
This bill clarifies the definition of practice audiology by specifying that practice audiology includes the prescribing, ordering, selling, dispensing, or fitting of a hearing aid to an individual for the correction or relief of a condition for which such devices are worn. There are amendments on page 34 of your packet that were considered in the Health Occupations and Long-Term Care Subcommittee. Amendment number 1 changes the sponsor and makes technical changes. Amendment number 2 strikes references to Osseo integrated devices. Amendment number 3 clarifies that the definition of hearing aid dispensing includes ordering prescription hearing aids. And amendment number 4 clarifies that specified provisions of state law that conflict with federal law and regulations do not apply to over-the-counter hearing aids and changes the effective date.
Okay, Delegate Rosenberg.
This was unanimous in the committee, and this is an instance where, if I may, the parties were not listening to each other at the outset. Well, you're listening to me, at least.
That was.
Do I get negative points for that?
Well, I think, let's just leave it there. Go ahead, you finish.
But they reached agreement,
Okay,
and we concur in that agreement and would urge the full committee to do so as well.
all right. Can you move the amendments? Move the amendments. It's been moved in second. Any discussions on the amendments? Delegate Shalega.
Clarify, the ENTs were fine with this in the end. Everybody is. Thank you.
Thank you for the question. All right. All those in favor of the amendment say aye. Aye. Any opposition? On the bill as amended. The bill is amended. It's been moved in second. Any discussion? Seeing none, all those in favor say aye. Aye. Any opposition to the bill as amended? Seeing none, who does not want to be on the bill? Raise your hand. All right, thank you. So next, we have House Bill 418, Mental Health. I'm going to hold that one, 418. On the last one, we did the amendments in the bill. Yeah, we did.
Delegate, you didn't hear it.
All right. Guys, come on. Let's keep it straight. Let's keep it moving. It's okay. So we're holding 418, okay? Yes.
While we're on a break, because we only get one hold, I do not want to use my one hold on the bill earlier.
You do not?
I'm not, because I only get one hold. Yeah. I only get one hold for the whole session. That is.
No. The bill can only be held once.
Okay, but we are not limited to one hold per
No.
member? Okay.
Okay? But don't abuse it. Let me rephrase that. Let me rephrase it. The bill can only be held only once, right? And you can ask for a hold on a bill, right? However, when we get closer to, crossover or end of session, I can say no. And also, I like you to keep in mind that what you do here, they can do to you across the street. So be very thoughtful about when you want to hold a bill. If you have problems with the bill, right, honest problems with it, we'll hold it, because we want to pass a bill that does what it's intended to do, not just to pass the bill. So don't feel intimidated about holding it, okay? Just think about it. And remember that while it's in subcommittee, if you see it on the list for voting, that you're free to contact the LAs and ask them questions, or the sponsor of the bill as well, so it can be resolved before we get here, okay? Yes.
I don't, the issues that I have, I don't think are going to be changed. So I
Okay.
don't feel like I need to.
Okay, so we'll take it off the hold then.
Yeah.
All right, we'll go back to it. All right, but I don't want you to feel like you cannot, okay? So where were we? 420, okay. All right, so we're holding 418, and that's just a hold that I'm holding it. And then we are actually on hold, and that's gonna happen too for those that are new. Sometimes I get here and then there's an issue, I get a call or something, I have to hold it, okay? But it's not reflected on the sponsor or the advocates, all right? House Bill 420, Delegate Morgan, it is Aaron.
This bill requires the Health Services Cost Review Commission, when considering objective standards of efficiency and effectiveness, to determine the reasonableness of hospital rates, to do so in a manner that is consistent with the all-payer model contract. It was in Government Operations and Health Facilities, and there were no amendments.
All right, Delegate Kerr.
Vote in committee.
All right, is there a motion on the bill?
I move the bill.
All right, it's been moved in second. Any discussion on this bill? Does anyone have any concerns? Seeing none, seeing none, all those in favor say aye. Any objection? Opposition? Seeing none? Wonderful. Let's go to House Bill 453, and that is State Board of Physicians inactive and emeritus status, and that is Lindsay.
This bill authorizes the Maryland Board of Physicians to place a licensee on emeritus status under specified circumstances. The board must reinstate a licensee on emeritus status as specified. The bill repeals the current circumstances under which the board must issue a license to an individual on inactive status and alters the requirements a licensee on inactive status must meet for reinstatement. The bill exempts a licensee on emeritus status or inactive status from the 3-year limit on the term of a license and from continuing education requirements. A licensee on emeritus status or inactive status may not practice, attempt to practice, or offer to practice medicine in the state or delegate medical acts. There is a reprint of the bill beginning on page 38 of your packet with an amendment considered in the Health Occupation Subcommittee that clarifies that a physician on inactive or emeritus status must comply with continuing education requirements before resuming active practice. So while they're on inactive or emeritus status, they don't have to do CEs, but in order to go back to active practice, they will have to meet those requirements.
Thank you, Lindsay. Delegate Rosenberg.
Thank you, Madam Chair. This was unanimous, this was agreeable to all parties, and I would just add that the re-education, or, you know, that must be brought up to date is commensurate with the amount of time that the individual was no longer, was in an emeritus status and not practicing.
Are there any questions, Delegate Hill?
Clear, what is the difference is, and I think that I understand that the difference is they're both reinstatable. They both don't require any CMEs while they're on either inactive or emeritus. The inactive can be someone who was under discipline or had a revocation or had some discipline action at the time that they went inactive, whereas an emeritus cannot have had those conditions when they go emeritus. And an inactive has no minimum amount of time that they practiced in Maryland, but an emeritus has had to have been a practicing licensed physician for at least 10 years.
1 second.
And are those the only distinctions?
The other distinction would be use of the term doctor.
And the distinction being what?
For someone on emeritus status would still be able to use that, like, title.
I thought that neither could use the term doctor if it implied that they were practicing, but both can use the term doctor if they're not implying by using the term that they're practicing?
It specifies, if you're looking at the bill on page 4, it says a licensee who is on emeritus status, provided, can use it, provided that the licensee does not represent to the public that the licensee is authorized to practice medicine in the state.
Correct. And isn't that also true for an inactive, that they can still, they went to school and got a degree, as long as they're not implying that they're practicing, even an inactive physician can use that term?
Delegate Rosenberg.
Well, the language on the same page of the bill says that a licensee on inactive status may not practice, attempt to practice, or offer to practice medicine in the state or delegate medical acts.
But they can still use the term as long as they're not doing that. So that's not a distinction.
Delegate Shalega.
Yes, if you look on page 4 of the bill, the existing language with the intent to represent, so you know, a physician who's a physician gets to retain that position as long as they're not
Misrepresenting.
intent to represent that they're practicing.
So that's not a distinction. Is that right?
Okay. So the bill has amendments. I started the discussion without moving the amendments, but let's move the amendments. Second, moved in second. Any discussion? This is what we're having now. Any further discussion? Any concerns? All those in favor say aye. Any opposition? Seeing none on the bill as amended, is there a motion? Move the bill. Is there a second? Second. It's been moved in second. Is there a discussion or concerns? Seeing none, all those in favor say aye. Any opposition? Does someone not want to be on the bill? Delegate Kaiser. Okay. All right. And thank you for the questions. I really appreciate it. Now we're on to Delegate Hill's bill, House Bill 470. And that is Aaron.
This bill prohibits a person from setting oriented strand board on fire or burning oriented strand board for firefighting training purposes. A person who violates the bill's prohibition is subject to a civil penalty of up to $500 for a first violation and a civil penalty of up to $1,000 for a second or subsequent violation. This bill was considered in Public Health and Minority Health Disparity Subcommittee. There is an amendment that Delegate Bagnall would like to offer, and it's on page 43 of your packet.
Delegate Bagnall, can you please explain the process in the subcommittee, the vote, and the amendment, and why?
Yes, thank you, Madam Chair. So in subcommittee, this bill passed unanimously. It was in the same posture as it passed last year. It also passed out of the Senate. However, after subcommittee, we learned that the Senate had taken a floor amendment that we became aware of. It was a compromise. The firefighters are good with the compromise. MDE is good with the compromise, but they bifurcated the penalties. You'll see that there's a civil penalties in the bill. They wanted to make it an administrative penalty for the first infraction and a civil penalty for the second infraction. So that is the amendment that I am offering to make it conform to the Senate bill.
Is there a discussion on the amendment that is being offered or any concerns? Delegate Johnson.
I would just like to ask Delegate Bagnall to explain the difference between the civil and administrative penalties, how it would affect these firefighters.
That I'm going to turn to our counsel to explain the difference.
Administrative penalty, MDE could just assess, and then it wouldn't involve, you wouldn't have to get a lawyer, you wouldn't have to involve the legal system as much. And then the civil penalty would have to involve the court system.
And you can anticipate that question on the floor. Yep. Any other questions or concerns? Okay, so on the amendments, may I have a motion? Is there a second? It moved in second, and we just discussed it. Any further discussion? Seeing none, all those in favor say aye. Any opposition? On the bill as amended, may I have a motion? It's been moved in second. Any discussion? Seeing none, all those in favor say aye. Any opposition? All right, is there, 1 minute. Are there amendments on this bill? We just did it. So does someone not want to be on it, on the bill? Okay, great. You don't want to, oh, you're kidding me? Delegate Hill, Delegate Hill, Delegate Hill, Delegate Hill. All right, so we're gonna do Delegate Hill is gonna remove her name from that bill and give it to Ashanti Martinez. Okay, so we have House Bill 497. No, House Bill 497, Rural Health Collaborative, Pilot Repeal, and Mid-Shore Health Improvement Coalition Funding. That is Erin.
This bill repeals the Rural Health Collaborative Pilot and beginning in fiscal 2024 requires the governor to provide an annual appropriation in the state budget to fund the operations of the Mid-Shore Health Improvement Coalition.
Delegate Kerr.
Thank you, Madam Chair. Unanimous vote in subcommittee. There are no amendments. I move the bill.
It's been moved in second. Any discussion or concerns? Seeing none, all those in favor say aye. Any opposition? All right, thank you very much. Next, we have House Bill 633, Hospital Credentialing Reappointment Process for Physician Staff Modification. Erin.
This bill alters the minimum standards for a physician credentialing process that a hospital must have in place as a condition of licensure. The formal written reappointment process for physicians must be conducted in accordance with standards of the accreditation body that accredits a hospital rather than at least every 2 years.
Okay, and that is Delegate Kerr.
Thank you again, Madam Chair, and once again, unanimous vote in subcommittee, no amendments. I move the bill.
It's been moved in second. Any discussion or concerns? Seeing none, all those in favor say aye. Any opposition? Seeing none, thank you. Let's go back to the one that has been released. I hear there is a bird bill. Which one is that one? It was House Bill 278. Let's go back to House Bill 278, the Health Occupations Clinical Nurse Specialist Prescribing. Lindsay.
Do you want me to go through it all again?
Yeah.
Okay, this is the bill that authorizes clinical nurse specialists to prescribe drugs and durable medical equipment. The bill designates a CNS as an authorized prescriber under the Maryland Pharmacy Act. Practice as CNS is governed by rules and regulations adopted by the Board of Nursing and that concern additional acts in the practice of registered nursing. There's a reprint of the bill on page 21 of your packet that includes individuals who hold a multi-state license under the Nurse Licensure Compact under the definition of clinical nurse specialist and makes technical changes to the cross-references under the Maryland Pharmacy Act. This was considered in Health Occupation Subcommittee.
Can someone move the amendments? Is there a second? Any discussion on the amendments? Any concerns? Seeing none on the amendments, is there, no, on the amendments, all those in favor say aye. Any opposition? On the bill as amended? To move in second, any discussion? Yes.
Delegate Hill, can I direct a question to her?
Sure.
I just wanted her to explain what her concerns were with the bill before I vote.
Okay, thank you, Delegate Austin. So in the last, 8 years, we spent a lot of time worrying about controlled dangerous substances and who should have prescribing power over those things. We've had bills about whether podiatrists could prescribe those things. When it comes to these advanced practice nurses, it just seems that when they want to expand, we just sort of move ahead, but we do have a precedent when the clinical or the certified nurse anesthetist got full independent authority to practice without oversight or collaboration. We limited their ability to write controlled substances to a few days because they're taking care of perioperative and postoperative patients. The idea wasn't that they should just be able to write prescriptions. This particular group, the CNAs, as was presented to us and everything I read, they're not like nurse practitioners doing primary care. They're coordinating care for sort of communities and hospitals, and they work more as administrative and practice-based, and I can't see where they're doing a particular amount of prescribing. So my concern was, why are we so lax about giving this group Schedule to control dangerous substances authority when we have been so overly concerned about other practitioners like dentists and podiatrists? That was why I raised the issue.
Delegate Rosenberg?
Well, I think that all the parties that were involved on this legislation felt that this was appropriate and that the bill as amended provided adequate protection for patients.
And that's, I mean, I'm sure that's, and again, my experience has been that when the nursing board comes and says, we want people to practice to the highest level of their license, we don't differentiate. And they say they're all the same, but they're a nurse practitioner, a nurse midwife, a nurse anesthetist, and this nurse specialist. They're different. They all have doctorates, but they're trained differently. And because the Board of Nursing says they're all doctors of nursing, we don't dig any deeper, and we give them the same authority with the one exception of nurse anesthetist. And I just question why we are so lax, or it's not that we wouldn't still get there, but we don't look very hard at them. But we spend a lot of time worrying about podiatrists. We spend a lot of time worrying about where the dentist should have prescribing power. We spend a lot of time with all these other people, but we don't do so with nursing and advanced nurses.
So I like to say that the CNS and nurse practitioner are trained and educated in the same nursing program at the University of Maryland School of Nursing, and they're equally qualified to prescribe. When a nurse graduates from the program, they may seek licensure as either. They should not be treated differently. That's what we heard when it comes to prescribing authority. And also a reminder that MedCai took no position on the bill, and we have only 300 CNS in Maryland currently. So the bill is important to fill in that gap in care. There may be, you may have some differences, but that was the reasoning behind the fact, why the committee voted the way it did. Because we focus a lot on access to care in this committee. But I respect your views. Okay, are there any other concerns? Thank you. So this bill was favorable with amendments. On the bill, on the amendments, all those in favor say aye. Any opposition to the amendments? All right, on the bill as amended, it's been moved in second. Any concerns or questions? Seeing, oh, go ahead.
And
Yes.
again, I'm fine, I'm not opposing the bill, but it has to do with the description of job duties. So whereas a nurse practitioner's duties are health assessments, diagnostic testing, promote disease prevention, education of patients and families, diagnose and treat, provide referrals to specialists, prescriptive authority, and direct patient care, CNS is expert consultation, applies evidence-based research, patient outcome improvements, system outcome improvements, develop policies and procedures, educate and train staff, healthcare administrations. They, by their own description, don't have much clinical, and that was why. So I absolutely hear what was said, but I didn't want it to go on the record that just because they have similar training means their responsibilities are the same. Thank you.
No, and that's fair. Thank you, and thank you for bringing it. I mean, this is the place, so I welcome it, okay? So the bill has been moved as amended. It's been moved in second. Any other concerns or questions? Delegate Bandari.
Yeah, based on my research and the hearing, these clinical nurses, they complete additional education and training when they're doing their master or doctoral level. And this bill try to help them to practice to the full extent of their training.
Okay, thank you. Any other concerns or questions or comments? All right. All those in favor, because the bill was moved second as amended, say aye. Any opposition? Seeing none, all right. Is there someone that does not want to be on the bill? Delegate Hill. All right. Thank you, Delegate Hill, for the discussion. It's always welcome. So we have the last bill of the day is House Bill 705, Declaration of Rights, Right to Reproduct. No, we're holding that bill.
Just hold.
Yeah, we're going to hold that bill till sometime in the future. All right, so and thank you for the question. We appreciate it. Because sometimes we will miss things, so we appreciate your work. We're doing now House Bill 705, Declaration of Rights, Right to Reproductive Freedom, and that is Aaron.
House Bill 705 is a proposed constitutional amendment, if approved by the voters at the next general election to be held in November 2024, that establishes an individual's fundamental right to reproductive freedom, including but not limited to the ability to make and effectuate decisions to prevent, continue, or end one's own pregnancy, and prohibits the state from directly or indirectly denying, burdening, or abridging the right unless justified by a compelling state interest achieved by the least restrictive means.
Thank you, Aaron. So we had this bill last year. It passed the House. It did not pass the Senate. It didn't, excuse me? It didn't get a vote. So this year, we have the bill again. Just like last year, we gave this bill a full hearing, like we do in this committee, where we allowed everyone, regardless of how you feel, to come forward and tell us your opinion on it. We've been getting emails on it as well. We have had a very full, rich discussion on the bill, and the bill is before you for a vote. Again, this will be the second year. So it doesn't have any amendments, and I moved the bill, and then we open it up for discussion. So it's been moved and second, any discussion on this bill. And this is the place to do it. Delegate Kipke.
Thank you, Madam Chairman. I just want to say I have to vote against this bill. I think it's unnecessary. Maryland has very strong laws that are pro-choice laws. There's no threat to that in any of our lifetimes. And, you know, enshrining this in the state constitution is very offensive to a lot of pro-life Marylanders, including me, particularly because, and I do believe it will have an impact on expanding late-term abortion in our state. There's a lot of talk about, I forget the term that's used, tourism around this subject, reproductive tourism, I think is what people call it. And it just makes me very sad that Maryland will have a dramatic uptick in late-term abortions, as Maryland's law currently allows for that to happen. And it does happen today in Maryland. There are late-term abortions after the 8th month in the state of Maryland. And I know some people just believe that people should have that right. I just don't happen to be one of them. Thank you.
And thank you. And I would say for the record that this bill puts it up to the voters, for the voters to decide. When our initial laws were passed in the early 90s, the law of the land was Roe v. Wade, which basically said that reproductive freedom was a fundamental right. The law of the land presently has changed with Dobbs. The Supreme Court changed that. And it basically said that it was no longer a fundamental right, but that it needed to go back to the states for the states to decide. The Constitution is the strongest document for protection. And that is the reason why we have this bill. And the voters will get to decide individually how they will vote on it. I know Delegate Rosenberg has a comment, then I'm going to go to Delegate Chisholm. And thank you, Delegate.
Thank you, Madam Chair. I would make 2 points. One about late-term abortions. Late-term abortions are permitted under the existing Maryland law only in a very limited set of circumstances. And if there is a woman, we all know what the law is, and it says that after the medical provider, the healthcare provider using clinical judgment, believes that the fetus is capable of sustained survival outside the womb, in that circumstance, then the abortion can be performed only if there is a threat to the life or health of the mother, or if the fetus has a serious defect or abnormality. Many of these are emergency situations. And the so-called tourism is because people live in states where their fundamental rights have been severely restricted. And they are coming here because in Maryland, we have taken steps not only to ensure that the right exists, but there is access. That's what we did last year with our legislation, the Access to Abortion Act that we passed over the governor's veto. And then finally, I would just reemphasize the point made by the chair. I think it's a fundamental aspect of democracy and civics that we give our voters of all genders the opportunity to express their views on such a fundamental issue in light of the public response to the court's decision in Dobbs. From Kansas to Michigan, people have expressed their views, and the people whom we represent are entitled to that same opportunity, and that's what this bill would do. Thank you.
Thank you, Delegate. Delegate Chisholm? Delegate Shalika?
Thank you, Madam Chair.
My
I was
pleasure.
not going to speak on this, but I felt compelled to just clarify something that Delegate Rosenberg said. Yes, late-term abortions are lawful and permitted in Maryland for the mental health of the mother without regard to the health of the fetus, without regard to the health of the baby and its viability outside of the womb. So every mainstream pro-life group agrees with you, Delegate Rosenberg, that life of the mother, and if there is a serious anomaly with the baby, that abortion should be allowed. It should be the choice of the parents, the mother. But the loophole of the mental health is what is so offensive for late-term abortions to many of us, that does not require a mental health consultation or health care afterwards. So, you know, that, I think you know that. We've debated this on the House floor, but just to be clear for the record, that is the truth with late-term abortion in the state of Maryland. Thank you.
Delegate actually, I saw Delegate Hutchinson first, followed by Delegate Morgan.
Thank you, Madam Chair.
You're welcome.
This is probably more of a teaching moment for me, but when something goes into our state constitution, regardless of whether it's this bill or not, we are then limited in terms of being able to restrict or modify, or how does that work in terms of our ability as the General Assembly to potentially change
So
that?
you're in luck. We have a constitutional scholar in our committee, and that is Delegate Rosenberg. Thank you for your question.
Thank you for the designation.
My pleasure. You earned it.
Thank you. Yes, I did. The bill, if it enacted by the voters, includes the language compelling state interest further, that the state could act and limit the right when it is furthering a compelling state interest by the least restrictive means. And that is a term from constitutional law for decades, federal and state, so that the courts would be using that principle to, if a challenge were brought to any statutory provision or any action, regulatory action by the executive branch. And that is a well-known principle of constitutional law.
My pleasure. Delegate Morgan.
Thank you, Madam Chair.
My pleasure.
Yeah, I must inform everybody, I'm going to vote no. We beat this up pretty good last year, both in committee and on the floor. As far as late-term abortions go, Delegate Clay is absolutely correct. If you just do a Google search for late-term abortions, Maryland, pops up a website, abortionclinics.org, where you can schedule an appointment online, right in Bethesda, Maryland. My question, though, is the language the same as it was last year?
There are some minor changes, and Aaron would tell us, into one word. It's one word.
Is it?
It was the, 1 second, give us a minute. It's almost identical, but we substitute for reproductive freedom.
Okay.
Yeah, that's it. Yeah, that's the only change.
So when the text says that every person has the right to reproductive freedom, does that include males? And would they have some say? Because last time I checked, it took two to tango still.
So reproductive freedom is more than abortion, right? It's contraceptive as well. It is a vasectomy as well. But in this instant, if I may, this is about a person, right? Being able that is carrying that child, being able to make that decision to have the right to autonomy over her own body with her provider.
I understand the intent. I'm asking every person. That wouldn't include males.
Delegate Hill.
I think it absolutely does, but it's what the reproductive freedom is. So right now, women are the only ones who have reproductive freedom with respect to bearing, carrying, and birthing children. That could change, and probably will at some point. But the male is covered under this bill because he has the reproductive freedom as to whether or not he'll have a vasectomy or reverse his vasectomy without the government telling him he can't, or being sterilized because the government decides that he's has some reason that we don't want his sperm to continue to populate. So that's reproductive freedom for men.
I understand, and look, I take your points, and I know that you're trying to accomplish here, but I read this phrase, and between that and the late-term abortion issue, I think we're opening Pandora's box, because at some point, this will be getting litigated at some point, and I'm just not comfortable with it, so thank you.
No, and I appreciate your thoughts. This is where we come and we talk, right? And have the discussion respectfully. We all come from different areas. We have different upbringings, right, and beliefs, and we try to come up with good policy that is balanced and fair. So any other concerns or questions from anyone? Okay. All right. Seeing none, all those in favor? I did not see your light. Go ahead.
Yeah, after reading and listening all this discussion, I was born in different faith. Like I was born far, 8,000 miles away in Nepal. But I'm voting for this bill because these reproductive choices should be made by individuals, not the government. And those choices are deeply personal and should be made by individual in consultation with their healthcare providers and based on their own personal belief and the values. The government should not interfere in this decision or impose restrictions that limit access to safe and their legal reproductive care, and it's the individual rights. That's how I feel like, and I'm voting for it.
Thank you. Delegate Lewis.
Thank you, Madam Chair. I'd like to speak on my decision to vote yes on this bill. I think it's important to understand that reproductive freedom entails the right to bear children, to foster, adopt, and raise children that someone else birthed. And it also encompasses the right not to have children at all. And that includes people who decide to, for example, use contraception to delay or prevent pregnancy. It includes those who have made a choice to live their lives in different ways that don't involve raising children. As someone who chose actively not to become a parent, I think that my right to not be forced to bear children is one that's worth defending. This bill includes folks like me. There are plenty of men on this planet who do not wish to become parents, and I think their right to choose whether and when to become a father should be protected as well. Anyone else on any spectrum you choose to define in any human culture or society should have their right to bodily autonomy, their choice to parent respected. That's one reason why I'm voting yes on this bill. I'll also mention that in the decades before I joined this august body and became a state delegate, I worked in 14 countries on 3 continents on this planet in the field of international public health, including a lot of work on infectious disease prevention, HIV and AIDS prevention, malaria, tuberculosis prevention, vaccine development for West Nile virus, all of these various approaches to keeping people alive and protected from infectious disease. But my work also included reproductive health and rights and sexual rights for people. And one of the things I learned and I counted on was that while I was in countries in Asia and Africa and the Caribbean where women did not have access to contraception and couldn't choose when or whether to have children, women were dying. Women were choosing, as women have done since the beginning of time, to prevent or end their pregnancies. And in the countries where I worked, I know women who died, who lost their lives because they'd been denied access to contraception or other forms of protection and couldn't choose to control their fertility. They lost their lives in attempting to end a pregnancy that was not healthy, not safe, or not wanted, as was their right. In those days, I knew when I flew back home to the US that our right to control our fertility was protected, and I thought, my calling is to make sure that women in other parts of the world have that same security. And it never occurred to me that the day would come in this country when women here would be as unsafe, unprotected as women in far-flung countries with a lot less opportunity. Thinking of all the women I know who died in Nigeria, in Thailand, in Haiti, all for want of access to contraception and choice, I'll be voting yes on this bill in their memory. Thank you.
Delegate Chisholm.
Thank you, Madam Chair, and I think I can speak for most of the members in here that will be voting with me and voting no, in that we're not talking about contraception. Our problem is not with the contraception. Our problem is not with the first trimester, even second trimester. I think our biggest concern is we get into late-term abortion stuff, or even second trimester, and we continue to talk about bodily autonomy and individuals and defending these things. And we seem to talk all the time as if there's not another individual. That's why I wanted to know when viability was, because it is another individual. We're talking about 2 individuals with one person making the ultimate decision for 2 individuals. If it's because we're worried about the health of the mother, then all of us understand that. Nobody wants anybody to see harm. So we look at it, especially in these late-term abortions, as who's defending that individual. And that's what we're always trying to fight for. So we get lost in these euphemisms, and I think what is ultimately lost a lot of times in these conversations is the baby, a person, a product of God. And that's why it's so tough for all of us. So I think we can just table all the stuff about contraception and all that, because none of us really have a problem with that. Thank you, Madam Chair.
You're welcome. Delegate Rosenberg.
I would just, ironically, earlier today on the floor, I referenced my twin niece and nephew. Well, 31 years ago, when I was one of those who voted for the bill that's now our law that I referenced earlier, Rachel was 7 years old. She's now 38 and the mother of 2 wonderful girls, Liv and Ivy. And so whereas 31 years ago I thought only of Rachel in casting this vote and all the other women that I know, I now cast it in honor of Rachel, Liv, and Ivy.
Any other Comments? So look, the bill, if passed, puts it up to the voters, to our voters, every single person. We have a little over 6 million people, those that are registered to vote. Whether, you're male, female, you can vote if the bill passes. I want to thank you for an honest, respectful argument. Not argument, discussion, because it's not an argument. I respect everyone's feelings, and this is a safe place to have it. That being said, all those in favor of the bill say aye. Any opposition to the bill? Delegate Shalega, Delegate Chisholm, Delegate Morgan, Delegate Riley, Delegate Hutchinson, Delegate Kipke. And thank you all for expressing and for just being yourself and having it, okay? We really appreciate it. I want to thank, I know this is a tough issue and I respect it. I want to thank staff for their hard work this week because they have been working really hard, and for our team as well. I want to take a moment of personal privilege to thank my daughter who has volunteered for the last 2 weeks. She's been volunteering, helping out on the committee. We do have a wonderful new person. You want to introduce yourself? So she took Maricruz's place, and I want to thank all of you for being patient and working with us. If I can ask the committee just for a second, when we're done, if you could stay seated for a minute, please. And all of you watching at home, have a blessed weekend, and thank you for a healthy discussion. Can you take us off, please? Let me know when. Okay, thank you.